Welcome to the Courtroom Club.
Today, we're taking a closer look at something we, as part of Jonker Vorster Attorneys, deal with pretty much every day. Body corporate rules in South Africa.
That's right. If you own or live in a sectional title property, these rules are, well, they're fundamental. They really shape the living experience, don't they?
Absolutely. They're there to maintain harmony, protect everyone's rights, and ensure the smooth running of the scheme. It's crucial stuff.
And we see how important understanding them is for owners, tenants, trustees, managing agents, basically everyone involved.
Exactly. So, in this deep dive, we want to unpack what these rules are, the different kinds, how they're enforced, drawing on the law, specifically the Sectional Titles Schemes Management Act, or STSMA, and of course, our practical experience here at the firm.
Okay, let's jump right in. What exactly are body corporate rules in simple terms?
Essentially, they are legally binding regulations.
Hmm.
Think of them maybe as the internal laws for a specific sectional title scheme.
Right, so not just guidelines, but actual rules everyone has to follow.
Precisely. And they govern both conduct how people behave and the management of the common property. Their foundation is the STSMA.
And why do we need them? What's their main purpose?
Well, primarily, it's about preventing conflict. When you have many people sharing spaces, clear rules help avoid disputes over things like noise or parking.
Makes sense. Keep the peace.
Yes, and also ensuring the common property, pools, gardens, passages is used correctly and maintained properly. It's all about fostering a safe and harmonious environment.
Okay. So important for day-to-day living. You mentioned different kinds of rules.
Yes, the Act distinguishes between two main types. You've got the prescribed management rules, the PMRs, and the prescribed conduct rules, the PCRs.
PMRs and PCRs, what's the difference?
So think of it like this. Management rules, the PMRs, are about the administration, how the body corporate itself runs.
Like the behind-the-scenes stuff.
Exactly. Things like how trustees are elected, what their duties are, financial management,
Yeah.
budgets, levies, and the procedures for meetings, like AGMs and special general meetings.
Yeah.
It's the operational framework.
Got it. The governance part. So what about the conduct rules, the PCRs?
Right. The PCRs are more about the behavior of residents and how everyone uses the property, both their own sections and the common areas. These are the ones most people interact with daily.
Okay, like what specifically?
Oh, common examples are noise restrictions, setting quiet hours, for instance. Parking rules are a big one. How common areas like a pool or clubhouse can be used.
And pets. That always comes up.
Definitely. Pet policies fall under PCRs. And things like refuse disposal guidelines. It's about considerate community living.
These sound like the rules that really impact residents directly. Now, these rules aren't set in stone forever, are they? Can schemes change them?
Yes, they can. While every scheme starts with the standard prescribed rules from the Act's regulations, communities often find they need to tweak them or add rules specific to their needs.
So they can customize them. How does that work? Is there a process?
There is, and it's quite specific. To change the management rules, the PMRs, you need a special resolution from the owners.
Which means a higher threshold vote, right? Like 75%.
Typically, yes, in both number and value, though the specifics can depend on the scheme's documents. For conduct rules, the PCRs, it's usually an ordinary resolution, a simple majority.
Okay, but is owner approval the final step?
No, and this is critical. After the owners vote, any amended rule, whether management or conduct, must be submitted to the Community Schemes Ombudsman Service, CSOS.
CSOS. Why is that necessary?
CSOS reviews the proposed rule change. They check if it's reasonable, if it complies with the law, and importantly, if it doesn't unfairly discriminate against anyone. Only once CSOS approves and certifies the rule does it become legally enforceable. It's a really important check and balance.
That oversight sounds crucial to prevent, well, unreasonable rules.
It really is. It protects owners and tenants from potentially unfair or even illegal rules being slipped in.
Thinking about customized rules, what common examples do you see in your practice at Jonker Vorster Attorneys? Rules that schemes add.
We see quite a few. Sometimes, especially in high-density schemes, they might want to limit the number of people allowed to live in a unit,
Oh, interesting. Why?
often due to pressure on shared resources like water or parking, or sometimes just to maintain a certain feel in the community. Another common one is restricting certain types of businesses being run from residential units.
Right, to avoid extra traffic or noise.
Exactly. And setting specific, maybe stricter quiet hours than the municipal bylaws is also something schemes often do, tailoring it to their residents' preferences.
Okay, so the rules exist. Maybe they've been customized and CSOS approved. What happens if someone breaks them? Who enforces them?
The primary responsibility lies with the trustees. They're elected by the owners to manage the scheme, and rule enforcement is a key part of that.
Can they delegate that? Sometimes there's a managing agent involved.
Yes, they often delegate the day-to-day enforcement tasks to a managing agent if the scheme employs one, but the ultimate responsibility still rests with the trustees.
And what actions can they actually take? Fines.
Well, usually the first step is a formal written warning, clearly stating the rule broken and requesting compliance.
Give someone a chance to fix it?
Precisely. If that doesn't work, and importantly, if the scheme has a proper CSOS-approved fine schedule in place, they can then levy fines.
Ah, so the fines themselves need to be pre-approved.
Absolutely. You can't just make up fines on the spot. They must be part of the approved rules, reasonable, and applied consistently.
What if warnings and fines don't resolve the issue?
Then the next step is usually escalating it. Often this means taking the dispute to CSOS for mediation or adjudication.
We mentioned CSOS approval for rules. Tell us more about their role in disputes.
CSOS is the dedicated body for resolving disputes in community schemes. They offer mediation, trying to help the parties reach an agreement. If that fails, they can make a binding ruling through adjudication. It's meant to be a more accessible and cost-effective alternative to going straight to court.
So a crucial service for both body corporates and residents.
Definitely. They handle a huge range of disputes related to rules, levies, meetings, repairs, pretty much anything that can cause conflict in a scheme.
Let's shift focus slightly to the people involved. Owners and tenants, what are their core rights and responsibilities regarding these rules? Let's start with owners.
Okay, owners. Big responsibility.
Yeah,
Pay your levies on time. That's non-negotiable, really. It funds everything.
the lifeblood, as you said.
Exactly. And owners are also responsible for ensuring their tenants abide by the rules. You can't just rent out your unit and wash your hands of it.
So the owner is ultimately accountable for their tenants' behavior.
Yes. On the right side, owners have the right to attend body corporate meetings, to vote on decisions, and generally participate in the scheme's governance.
And tenants, what are their obligations and rights?
Tenants are absolutely required to follow the conduct rules. Just because they don't own doesn't mean the rules don't apply. They live in the community.
And their rights.
They have the right to peaceful occupation and the reasonable enjoyment of the common property, just like owners, provided they follow the rules.
What if a tenant breaks a rule? Who deals with that?
Well, the complaint can go to the owner of the unit, who is then obliged to address it with their tenant. Or the complaint can go directly to the trustees or managing agent, who might then engage with both the tenant and the owner.
Understood. Now, looking at the legal side again, are there fundamental principles that all body corporate rules must obey, like absolute requirements?
Yes, there are some non-negotiables. Firstly, all rules must comply with the STSMA and the CSOS Act. That's the baseline.
Okay, statutory compliance.
Secondly, and this is vital, no rule can violate the South African Constitution or infringe on fundamental human rights. They can't be discriminatory or unreasonable.
So basic fairness and legality are paramount.
Absolutely. Thirdly, as we touched on with fines, any penalties must be set out in a formally approved, documented schedule. No arbitrary punishments.
Transparency again.
And that leads to the fourth point, accessibility. The rules must be readily available to all owners and tenants. Everyone needs to know what's expected of them.
Good governance principles, really. In our experience at the firm, what common misunderstandings pop up around these rules?
Oh, there are a few classics. One big one is the idea that the body corporate can evict a troublesome tenant.
They can't.
No. Eviction is a legal process that only the landlord, the unit owner, can initiate through the courts. The body corporate can apply pressure, issue warnings, fine the owner, but they can't physically evict the tenant themselves.
That's a really important distinction. Any others?
Yes, the belief that verbal rules or understandings are enforceable. They're not. If it's not written down and we're required CSOS approved, it doesn't hold legal weight.
So we've always done it this way doesn't cut it if it's not in the official rules.
Precisely. And also, the opposite misconception, that the rules you inherit when you buy into a scheme can never be changed. As we discussed, they absolutely can through the proper channels.
Right. We saw the source material mentioned, frequently asked questions. We don't need to list them all, but what kind of practical things do people typically ask about?
They often revolve around very practical issues, like, can they really fine me for this? Or what if I think a fine is unfair?
The money side of things.
Yes, and also about pets, always pets. Questions about how many, what types, where they can go. Also, noise disputes, parking problems, and clarifying what constitutes common property versus their own section.
So the rules really do touch on the everyday realities of living together.
Absolutely. These questions show just how impactful these rules are on daily life.
It's crystal clear then, these body corporate rules are far more than just admin. They are truly essential for a well-functioning sectional title scheme.
Couldn't agree more. They provide the necessary structure. Understanding them, whether you're an owner, tenant, or trustee, is key to preventing disputes and ensuring everyone can enjoy their property.
And for anyone listening who might be grappling with rule issues or perhaps needs help drafting or amending rules for their scheme, that's exactly where we at Jonker Vorster Attorneys come in.
Yes, this is core work for us. We guide body corporates and owners through the complexities of the STSMA and CSOS regulations daily. If you need assistance, please do reach out.
Definitely. So perhaps a final thought for our listeners. Take a moment to think about the rules in your specific scheme. Are they clear? Are they fair? Are there areas that maybe need updating or clarifying to better serve your community now?
That's a great takeaway. A proactive review can often prevent future headaches.